We have, pardon me, we have both counsel with us this morning. Mr. Horowitz, I believe you are here on behalf of the appellant. Did you wish to reserve time for rebuttal?
5 minutes, please. Good morning, Your Honors.
Good morning. I don't recall there being any cross appeal in this matter. Attorney, do you know, CEO, am I correct?
No, correct, Your Honor. No cross appeal.
That saves me from having to ask you whether you wanted to reserve time, right? Thank you. Okay. I had to do that in the last case and maintain all the flow of time. And we got to do it and nobody got harmed so far as I could tell. With that being said, we are ready for counsel for the appellant's presentation. Mr. Horowitz.
Good morning, Your Honors. I'm Greg Horowitz. I represent the appellants, the personal representatives of the estate of Fred G. Walker. They're his two children. When we first filed the case, they filed it on his behalf as power of attorney. And this case involves a de novo review of a denial of coverage on a long-term care insurance policy, and the judgment was entered in favor of appellee bankers. The case involves undisputed facts, interpretation of a contract, and interpretation of a statute. So it's all yours without deference to the trial court. The Mr. Walker, the insured, bought and for 19 years faithfully paid the premiums for a long-term home health care policy, which covered primary services, those of a registered nurse or the like, and a secondary services, including those of non-professional providers such as a home health aide. When, however, the insured received the services of a home health care aide of his picking, he was denied coverage. He was denied coverage on the ground that the policy expressly provided coverage for this type of secondary services only where such services were provided by a healthcare agency or a nurse registry. And the policy defines a home care health care agency as a specializes in giving nursing care or therapeutic services, or a nurse registry. And the issue before the court is that we believe that 627.940716 specifically invalidated the policy clause, which bankers relies on. You know, by the time the services were rendered.
So wait, let's focus on what you, I think, are arguing. I'll make sure I understand it. Is that the policy provision says these charges will be reimbursed if they're prescribed by a home health agency or a nurse registry, that constitutes an exclusion for home health aid services within the meaning of the statute. Have I got that right?
Yes, ma'am.
Okay.
Under 627.940171, and it's brief, let me just read the paragraph. Minimum standards for home health care benefits. A long-term care insurance policy, certificate or rider that contains a home health care benefit must meet or exceed the minimum standards specified in this section. The policy certificate or rider may not exclude benefits by any of the following means. Sub 6, excluding coverage for personal care services provided by a home health aide. Well, that's exactly what the banker's life is.
Wait, the policy doesn't exclude that coverage. It provides that it will reimburse for those benefits if they are provided through a home health agency or a nurse agency or nurse registry.
Right.
So we're not looking at an exclusionary clause in a policy. We're looking at a prescription for the method to receive the benefits. as opposed to an exclusion that says we won't cover home health aides?
Well, they've basically excluded coverage for personal care services by adding the conditions that the insured cannot hire a personal care services provided by a home.
Well, the insured, at the time these services were rendered, the insured was residing in an ALF, correct?
I believe he was
that's
residing at home.
The undisputed facts that are recited in the trial court's order that I don't think any of you quarreled with are that he received these services when he was residing in a facility.
Okay, that's not my understanding.
If I have that incorrect, I'd like to know.
Okay. Well, the policy is renewed every time a premium is paid annually, and that's undisputed. That the policy was renewed every year, and that pursuant to Florida case law cited in the brief, the insurance company policy automatically must conform with the statute. And in addition, the policy itself states that conformity with state statutes, policy is amended to conform to minimum requirements of state law. The minimum requirements of state law do not require the insured to be able to obtain benefits only if they order services through a home health care agency.
Well, the reason I'm asking, and I had the opportunity to check this, it's in the final judgment, and I don't think that you move for rehearing or that anybody has challenged this. The recitation is that while Mr. Walker was resident of an independent assisted living facility, his son retained a CNA to provide home health care services. And the reason that I'm asking about this is that from the perspective of an insurer, if somebody's in an ALF and you've got other health providers coming into the facility, would it not be a reasonable expectation to want to coordinate care among providers that are taking care of this insured in a facility?
Under this policy, all that required was that it be overseen by his doctor, and that the services provided by the CNA are pursuant to his doctor's orders. That's all that's required.
But the policy says if the home health aid, if the aid was prescribed by a home health agency, right?
Correct. And the claim was denied based on an amendment that was not approved by the state of Florida on 6/27/96. So under the statute 627.410(1), it is not part of the policy because it was not approved. It was approved.
Let me ask about that, because in the record, there is a stamped approval on a couple of documents. So I'm not sure what your argument is as far as it not being approved.
It was approved on 5/9/97. The appellee actually filed a copy of the policy to be considered at the summary judgment hearing. And it contained the date of 5/9/97 as the approval date, as when it was approved. That was evidence that they provided to the court at the summary shortly before the summary judgment hearing. I think it was less than a week or so.
But as you argued or pointed out in your brief, the policy is basically renewed annually. And isn't it renewed on the terms that are in effect at the time of renewal?
It could be seen that way.
This approval by the department was well before your client required home health care services, correct?
True. And the statute.
Let me maybe move it. I mean, I'm not sure I agree with your argument about whether the approval was adequate or not, but I think one of the things that is not really addressed or not addressed in any detail. Is the department's approval able to conclusively establish that it meets the requirements of the statute, or do we look to the statute to determine whether or not the policy is in compliance?
Right, it doesn't matter. Yeah, I agree with you. I think your point is that it really doesn't matter. You have to look at the statute because the statute controls no
Okay,
matter what the insurance policy said.
And to go to Judge LeBrit's questions, I want to ask you, because it does seem clear to me the policy does not give a blanket exclusion for home health care aides. The policy has a restriction on what would qualify for coverage. So is that an exclusion, or is that a restriction that doesn't meet the test of being an exclusion?
Well, I think it's an exclusion. However, I think the statutory interpretation, when you are interpreting home health care policies, is that if there's any ambiguity, that all doubt goes in favor of the insured, and we've cited to the case law there as well. And also the judge, I believe, first of all, she ruled based on a case that is inapplicable. It did not.
Can I slow you down for just a second? You're saying that the policy is ambiguous?
No, I'm saying if there's any doubt as to the interpretation,
The principle is that
whether or not there's an exclusion.
Okay, so whether the statute operates to render this an exclusion is where you say there's an ambiguity?
No, I'm
'Cause
saying.
I'm having to respond. Let me just get my question out there. If you're arguing that the policy is ambiguous and therefore should be construed favorably to the insured and in favor of coverage, I want to know where the ambiguity in the policy is. If you're saying that
It's not listed under exclusion. It's not listed under the exclusion section, but it in fact excludes a CNA unless they go through a home health care agency or a nurse registry, and that is not in the statute.
so the ambiguity that you're saying exists is that the restriction on when home health aides services the qualification on that come through a home health agency or a registry, that should be in the exclusion section of the policy, and that's what makes it ambiguous?
Yes, and I would cite to the court Bell Care Nurses Registry versus Continental Casualty Company, and it's cited in the brief, and I think it's right on point on this case, and I think this case should be decided on it. It's 25-7-3-13. And in that case, they found for that exact reason that the policy at issue was ambiguous because, in that case, it provided that the secondary services would only be paid if within a week primary services were also used by the insured, and the court in that case found that it is ambiguous, and you have to protect the people of the state of Florida from Philadelphia lawyers who write up contracts such as this, and to provide coverage in favor of the insured when a specific policy does not exclude the secondary services under the exclusion section. So if you take a look,
Mr. Horowitz, I'm not sure that I would agree that either the policy or the statute is ambiguous. But it seems to me the best argument that I think you can make is that based on the wording of the statute, which says that the policy may not exclude benefits by any of the following means, and then it's excluding coverage for personal care services by a home health aide, that in operation, the policy is excluding a benefit otherwise available under the policy for services provided by a home health aide. I mean, it seems to me you
agree.
didn't really focus on the language benefits, but that's what the statute seems to be tied into. It can't exclude benefits by excluding coverage. And so it goes back to my question of earlier, which again ties into Judge LeBrit's question. Is an insurance company entitled to narrow its coverage by imposing certain requirements? Well, we know they can narrow it by saying there's a daily limit. We know they can narrow it in certain different respects. The area that I'm troubled by is, can they not narrow it by saying, for whatever reason they deem appropriate, that we are more comfortable with providing this benefit when the aide is working in a registry or is working in an agency? Why is that, one, unreasonable, and two, why is that violative of the statute?
Because the statute does not state any qualifications, and there's the Latin phrase that I quoted in my brief, that the fact that it's not there means that there's nothing else that's meant to be there, and that the statute gives more coverage beneficial to the insured than the policy. So, and that's the statutory interpretation.
So to go back to something you said, earlier, where the statute says the policy may meet or exceed the minimum standards, then by restricting the coverage in this instance, it's not meeting or exceeding the minimum standards. It's adding another standard that further restricts the coverage.
That's well said. Yes.
Well, thank you.
Well, that's why you're an appellate judge and I'm just an attorney.
But don't take any of our questions.
I know.
Indicating where we're going with this. We're just
I've been doing this a while. I know. I know how it goes.
I mean, you've answered my question on that. I did want to ask you.
Let Mr. Horowitz know that we have invaded the corpus of his time, but I'm going to try to preserve it because I know he was responding to questions. Does someone have another question?
No, I'm actually satisfied with where we are. Thank you, Judge.
Thank you all. I'm going to hold you at 50 to preserve your time then. And let me stop the clock so counsel for the appellee is not overcharged here, so to speak. Okay. Attorney Dionisio, you may proceed.
Good morning. May it please the court. Again, my name is Kimberly Dionisio, and I represent Bankers Life and Casualty Company in both the trial matter and this appellate in this appeal.
If I might phrase the issue that has been discussed towards the end of Mr. Horst's presentation to get your response now, because it will tie in terms of recency and primacy a little better than wait till later. The statute 627.94.071 provides that the policy may not exclude benefits by excluding coverage for personal care services provided by a home health aide. Now, I note that it doesn't say excluding all coverage or what, but taking the statute as it's written, can you avoid that phraseology by saying in the payment schedule rather than the exclusions, we will not pay for the following, or is that permissible?
The statute is under the minimum standards for long-term care insurance policies. So the policy meets that minimum standards and goes further in the criteria to actually implement the Home Health Services Act under Chapter 400, starting with cited to by the appellant in his briefs. And that starts at, where is it?
I guess, what I'm wondering is, can you, by excluding payment, in effect, have the same operational effect as excluding coverage?
Well, I think there is an issue with the terminology used by the appellant as he interchanges home health care aide with independent caregiver. Home health care aide is defined in both the policy and the statutes. Independent caregiver is not. So the policy does not have a blanket exclusion. It actually expressly provides for benefits for services rendered by a home health care aide. There is no mention in the statutory provisions, whether it's 627 or 400, as to independent caregiver. And that's where I think this meets the rub between the two parties, because the appellant in his briefs continues to interchangeably use certified nursing assistant and independent caregiver with that of a home health aide. And home health aides are regulated and licensed under Chapter 400, and the policy both meets the minimum standards for long-term care policies in 627, as well as the Home Health Services Act under Chapter 400.
So on the record before the trial court, this individual that was providing care was not construed to be a home health aide, but rather a caregiver, a home caregiver, an independent caregiver?
The independent caregiver is not a defined term. So home health aide is a broader term, and it is defined under 400,
Right. Okay.
464. And as part of that, it does include a certified nursing assistant. From there, the
No.
Home Health Services
So
Act.
paragraph 17, right?
Correct.
It's defined in simple.
Correct, but you can't
Counsel,
just,
let me see if I can just jump in on this, because I don't want to go down a rabbit hole and use up a lot of your time. Your client is not rejecting payment based on the individuals not being qualified to provide services as a home health aide, correct?
it was a rejection based on his status as an independent caregiver, not as his status as a certified nursing assistant. He was not registered with an agency.
Okay, let's not go down though a rabbit trail.
Sure.
This individual, if he were or she were, I think it's a he, registered with a registry or an agency, payment would be made.
Correct, Your Honor.
Okay, so the fact that, whatever terms are being bandied about, your client's rejection is because he was not with the registry or with an agency.
A nurse's registry
Okay.
or a home health agency.
And so to go to one question that Judge LeBrit raised, and I want to double check on, the fact that the deceased was in a facility, your policy would provide coverage for a home health aide even in a facility, correct?
That was not an issue in this case.
Okay. So I wanted to make sure we're on the same page. I want to ask something totally different just before I forget about it, and I'm going to ask your opposing counsel as well. If in fact we were to reverse, and don't take anything out of the question, but if we were to reverse, opposing counsel has asked for entry of a judgment in his client's favor, but there are still affirmative defenses that would need to be addressed. Am I correct in that?
Yes, certain conditions precedent as to the submittal of the claims, correct?
Okay, so if any reversal, if we were to go that way, would be a remand for further proceedings.
Yes, Your Honor.
Okay, I just wanted to double check that before I forgot about it.
Are you finished, Judge Silverman?
For the moment.
I'd like to ask you a question, counsel, that I asked your opponent, which is, and I look at the policy and it seems that it provides under Schedule 1, $205 a day for nursing home and alternate facility care, and then under Schedule 2, another $205 potential benefit for home health care, respite care, hospice care, blah, blah, blah. The question that I asked your opponent is one that I would like to hear from you as well, which is, we know from the final judgment that Mr. Walker was resident in the LF. From your client's perspective, and it knows it's on the hook for these kinds of benefits where we don't have the case like Abrams where the policy limits benefits to truly a home health as opposed to providing those benefits in a facility. And that's sort of where my question comes from, which is, from your client's perspective, when somebody's in a facility and they're availing themselves of these sort of secondary benefits for an independent caregiver or home health aide, whatever you like, and I understand you have a beef with that terminology, but fundamentally a CNA that's coming into the nursing home to provide some sort of personal services to Mr. Walker, is it not reasonable for your client to want to coordinate that care? Is that the reason? Is that a potential reason for why the aide would need to come in through a registry or a home health agency? I could be completely out on a limb here, but I'm just curious if that is one of the potential explanations for why a registry as opposed to any licensed CNA can come in and do this.
It's, well, first, the company does not prescribe the way in which the policyholder spends their funds, and actually it looks to preserve the funds. So yes, as to double dipping as far as being in an ALF facility and then spending more funds for an additional caretaker, you know, the company does watch out as to depleting those funds, or making them
So
last
you're
longer.
avoiding duplicating services.
Right. But the company takes in the paperwork and processes the paperwork. It doesn't go out and certify the caregiver. So the policy establishes a criteria in which, and again, it implements this under the Home Health Services Act. It's the same criteria that an agency or registry appoints a home health aide to be in the home, and that's the oversight. Chapter 400 and this policy are not mutually exclusive. In fact, this policy implements the statutory provisions of the Home Health Services Act.
Well, a certified nursing assistant under Chapter 400 is specifically qualified to provide home health care services, correct?
Correct. When
So
affiliated.
the policy in its application in this instance seems to be adding more requirements than what is contemplated under law, because if a certified nursing assistant such as this individual has been determined by the state to be qualified to provide these services, and you're now saying, yes, but they also have to be part of a registry, they also have to be part of an agency, that seems to be adding a restriction that the wording of the statute doesn't contemplate.
Well, there's two statutes at issue, right, Your Honor. There's the 627 minimum provisions for long-term care policy, but more importantly, the criteria for benefits for a home health care aide is implementing the statutory scheme set forth in the Home Health Services Act, which contemplates home health aides are with a registry or an agency. And there's no.
Let me stop you there, because I want to clarify that.
Mhm.
Is it required under either statute that a home health aide must provide services through a registry or an agency?
Yes.
Okay, tell me where that is.
This is the whole statutory scheme. So there's.
But Chapter 400 and the administrative rules interpreting Chapter 400 all say that a CNA can provide home health services, period. It doesn't seem to say that they have to be part of a registry. And if I'm wrong, point me to that, because I think that's an important issue.
Yes, Your Honor. Going back to the definitions, pulling my sheet here, of which home health care aide is number 17. Certified nursing assistant would meet, sorry, I've lost a sheet of paper here.
Home health aide means a person who is trained or qualified as provided by rule and who provides hands-on personal care, performs simple procedures as an extension of therapy or nursing services, assist in ambulation or exercises, assist in administering medications as permitted in rule, and for which the person has received training established by the agency under this part, or performs tasks delegated to him or her under Chapter 464. That's what I have.
Great.
Yeah, you have a problem finding yours. Did I get the right one?
You got the right one. I was looking for it because there are a couple other definitions that come into play here. So certified nursing assistants are regulated under Chapter 464. So they're part of the the heading home health aide, but they are certified to do more. And so if you go to 15, subsection 15 of that statute, home health agency means a person that provides one or more home health services. Go to home health services, and 19 is the list of items that are provided. So the argument here is that a certified nursing assistant meets the definition of a home health agency and therefore has to be licensed under Chapter 400 of the Home Health Services Act. Now there's certain
hang on. So tell me where it says that home health care services may only be provided through an agency or a registry. Because I hear what you're trying to say as far as the definitions and who can do certain things, but it doesn't seem to require that a CNA who provides those services has to be with a registry or an agency. That seems to be something in your policy. So again, if I've missed that, help me find that.
Well, so a number of statutes, and I'll list them off here: 400.464, 400.476 deals with staffing requirements and training. A home health agency shall ensure that each certified nursing assistant employed by or under contract with a home health agency.
Okay, wait. Employed by them. So that,
Right.
that anticipates that, okay, if you are going to provide these services as an agency, here's what the things you have to do. I'm talking about the flip side of that, which is that if you are an individual who is certified or authorized by law to provide these services, that you can only do so through an agency or a registry.
Oh.
I understand the
Right.
certification aspect for agencies and registries, but it's the other side that we're worried about.
The statutory definition, so a certified nursing assistant would meet the statutory definition for home health agency and therefore requires licensure. There are certain exemptions around that, but that is not on the record of appeal. There has nothing in the record on appeal as to the certified nursing assistant in this instance for Mr. Walker being exempt from the licensure requirements under Chapter 400.
Can I ask you to
I'm
go
still-
back to the definition that you had a moment ago in 15? It says home health agency means a person that provides one or more home health services. This gentleman is a person, right?
Correct.
So
So
he would become a home health agency by definition.
correct.
So how is he denied for not being employed by a home health agency if he is a person that provides home health services?
He did not go through the licensure process under Chapter 14 to be a licensed home health agency or a nurse's registry. And that is upon which this claim was denied, because Mr. Chalut was not a nurse's registry or a home health agency. And again, there are certain exemptions that an independent caregiver can receive, but that is not an issue on the record on appeal.
Okay, so that would be based on subparagraph 17, that a home health agency is a person who was trained or qualified as provided by rule. Is that where I would go, that one, to link that aid under agency? Because it just says home health agency means a person that provides one or more home health services. It doesn't say anything about licensure in the definition.
Right. So,
15. Where would I go to follow up on that?
so then to 19 is the home health services.
Thank you.
So a
Okay,
CNA
gotcha.
would meet. Okay. And then you would
Gotcha.
go to the licensure that home health agencies to be licensed, 400.464. And then there's a similar provision for nurses registry. Licensure of nurse registries, 400.506. And these home health agencies, there's no centralized Florida agency that regulates the home health care agency. It's by the statute within the purview of the licensed home health agency and the licensed nurse registries.
So when the Florida Administrative Code provides that a CNA may work as a home health aide, your position is that's true, but only if they work with an agency or a registry.
In this case, that is true.
Why?
Yes.
Why in this case?
That's because the CNA
I mean,
here
it's either a broad rule of law that you are saying anybody who's providing home health care as a home health care aide must be affiliated with a registry or an agency, whether they're a CNA or some lower or higher designation. And that, I think that's what you've just argued in the last 5 minutes is.
Yes, you're right. So yes, Your Honor. And that brings it back to 627, where where the statutory provision prohibits a policy from excluding services by a home health aide. And that home health aide is, again, a statutory definition that is regulated under Chapter 400. And the criteria for provider eligibility is the same that exists in Chapter 400. So the same provider eligibility criteria in the Banker's Life policy models Chapter 400 is in compliance with that statutory scheme.
So a home health, the language in 400.46217, you seem to be saying it doesn't mean what it says, because what it says is a home health aide is, and you know the definition, I'm not going to read the whole thing.
Mm-hmm.
But it's a person who has received training established by the agency, which is referring not to an agency providing services. It's referring to the agency under which this entire chapter is devoted, the Agency for Healthcare Administration.
Right. The appellant cannot isolate that one definition without looking at that definition.
Well, let me ask one other question, and then I'm going to let this go. Has any of this been argued in the brief or in the trial court? Because I candidly do not recall there being an argument that as a matter of law, a home health care aide must work in an agency or a registry. I thought the entire argument presented to the trial court and now on appeal is our policy has a restriction that is appropriate for whatever reason. And by the way, that does not exclude coverage. So is this a new theory that you are positing we should tag on to? Because I do not recall this being argued.
It was more so going down the rabbit hole of how the policy both implements the minimum standards of 627 and the entire statutory scheme set forth under the Home Health Services Act. The criteria in the policy matches up to that act. I'm saying
but the trial court didn't rule on any of that. The only thing the trial court ruled on is the language of your policy does not constitute an exclusion. So it seems to me we have spent the last 10 minutes talking about an issue that has not been raised in the trial court and has not been briefed for this court.
Well, we got on this tangent because the appellant is interchangeably using certified nursing assistant with independent caregiver with that.
But that's also irrelevant because this individual qualifies as a home health care aide. It seems to be there's no dispute about that because he's a CNA, qualifies. So now we're spending 12 minutes on issues that have nothing to do with the ultimate resolution of this case.
That is to establish that this home health care aide is further regulated by Chapter 400 and that the policy itself models Chapter 400 as to the criteria for provider eligibility.
Is your client's position that the only way that the appellant could win in this case in trial or on appeal is if the policy says we exclude coverage for home health aides? And maybe a policy can be written that says that, but not a long-term care policy.
The issue here, this wasn't a blanket exclusion for home health aides.
Right.
It was, in effect, a denial of coverage for an independent caregiver. So there's a distinction, and that is the interchangeable words that are at issue in this case. There's no blanket exclusion.
I understand that we want to characterize it that way. But his bills were submitted under the rubric of home health care, and he is qualified as a home health care aide. Your client didn't deny it because he's not qualified as a home health care aide. Your client denied it because it's not within, he's not working through a registry or an agency.
Correct. And if you flip to the policy, it starts on 825. But if you go to covered expenses and the amendment rider, so we're looking at 836 and 830 in the record, the policy provides reimbursement of expenses for services under a written home care plan, which is recommended or prescribed by a home health care agency or provided by a nurse registry as licensed in Florida under Chapter 400. That models the requirements under Chapter 400, the Home Health Services Act. And then included within that.
But the statutes also have language, and I did not make a note of where it was, but it also discusses that the home health care services can be provided under the supervision and authority of a doctor. It doesn't seem to tie it in exclusively to an agency or a registry.
It requires a physician's order, but Chapter 400 also contemplates that these agencies and registries establish a plan of care for the in-home resident. If you go to 400.487, subsection 4.
And that makes sense. That makes sense if someone is working for a registry or an agency, that it has to be within the parameters that they have. But I mean, I guess this will be my last question because I've taken up too much of your time. But bottom line is, you seem to be setting out a position on behalf of your client that home health aides who are not affiliated with a registry or an agency are legally prohibited from providing services. Because you're making the argument that in order to do any of this, you've got to be with an agency or a registry.
Unless they somehow apply and are approved for an exemption from regulation under Chapter 400. Correct.
And this rejection of coverage was not based on this individual not meeting one of those exceptions, perhaps. And we don't know that from this record, correct?
It's an affirmative, it's an exemption that the applicant has to make to the state to operate as an independent caregiver outside the purview of Chapter 400.
And we don't have any information to elucidate that one way or the other, and that's not what your denial of coverage was based on. Your denial of coverage could have been based on that fact, but it wasn't. And so this doesn't seem to me to be a tipsy coachman argument, because I don't know what this guy's qualifications are because nobody has raised it in the trial court.
There's nothing in the record that you can rely on.
Anyway, I will turn my microphone off. I've asked as much as I can.
Counsel, I would tell you that you're at 24 and a half minutes, but I'm going to pause on that one because I want to make sure that you may have some prepared commentary you would like to have given us before we took you on the proverbial roller coaster ride to answer all of our questions. And I'm prepared to give you some extra time to present that to us because I don't want you to be foreclosed.
All right, I will end with my conclusion then, Your Honors. The Bankers Life policy provision is not void against public policy. And in fact, actually implements the express purpose of the Home Health Services Act in Chapter 400, which is to provide for basic standards that will ensure the safe and adequate care of persons receiving home health care services in their own home. The Bankers Life policy bolsters the express purpose of this act by ensuring oversight. And similarly, this act is to provide for the licensure of every home health agency and nurse registry. And in that, they're training and appointment of home health aides. Case in point, the very act that the appellant cites to deals with the licensure, which we just discussed. And the act contemplates the oversight and governance over home health aides. The applicant cannot isolate the definition of home health aide in Chapter 400 in the act without, it can't isolate that definition, as the individual statutory provisions must be interpreted in the context of the overall statutory scheme of both 400 and the insurance code dealing with long-term insurance contracts. Finally, the policy is not ambiguous. The policy complies with the Florida Insurance Code and the minimum standards set forth in 627 and actually implements those provisions by providing criteria for provider eligibility. The statutory definition relied upon by the appellant fails to take in the overall statutory scheme of the licensure of agencies and registries under 400, and the record on appeal does not support the extension of coverage for an independent caregiver who is not staffed with an agency or registry. Thank you very much.
Thank you, counsel. Mr. Horwitz, you have your time reserved for rebuttal.
Mr. Horwitz, let me just ask that question that I asked opposing counsel.
Yes, I agree with appellee's counsel.
It would have to be remanded.
You're right.
Okay, thank you.
I think the court has it, what the court has to, decide on exactly. I would ask the court to find that under statutory interpretation, and the case law cited that, my client's, CNA qualifies and, under the statute 627.940716, and that the banker's policy requiring a CNA to be with a home health care agency or nurse registry is more restrictive than the statute, and therefore, under the interpretation that the court should provide under the statutory construction, that if it's not there, the legislature meant no other qualifications to be there. And there are no other arguments regarding the CNA not being legally qualified to give the services. So I would ask the court remand with instructions as the court sees fit. Thank you.
Thank you, counsel. Thank you both. Very interesting today, challenging, always is when the legislature and the courts are at play, right? And the words that are used and their ordinary meaning and all those wonderful trains that we get to ride. I thank you for your presentations today on behalf of the panel. Well done, and wish you safe travels and good health.
Thank you. Great to see you all. Good growing old with you guys.
It reminds
Not the
me
lady,
of,
not the lady judge.
it reminds
very young.
me of the old gentleman, Justin Wilson, who used to be the cooking Cajun on PBS. I am too, and glad for you to see me.
Yeah.
We will go on to case number 3 on our docket today. Evanston Insurance Company and Everest Denali is our third case. For those that are listening, I would advise you that there's a strong likelihood that the panel will take a short break after this case is concluded.